So we can move to our first item on the agenda, which is the art.com sign revocation or modification. We're going to have a little changing of the guard here. Oh, maybe not. Is Arlie going to present?
I'll be presenting part of this, and outside counsel Ben Stock will be presenting another part.
I was going to say, if the staff, you have any questions of the staff, please direct them towards Maru.
Good evening, Commissioners, Chair Coomerly. So tonight we are considering an administrative item, which is an order to initiate an action to revoke or modify the existing art.com sign permit. I'm going to give some very brief background and then turn it over to Ben Stock. So as you know, this sign is on 2100 Powell, one of the buildings that's part of the Watergate office towers across from PPP, across the freeway. So the two signs face north and south on either end of the building. This is a basic image of the sign and some of the renderings from the amended proposal that was approved. The sign that exists now was approved as an amendment on February 23rd, 2012. In June, shortly after the sign went up, staff received some complaints about the brightness, especially at night. Art.com responded by dimming the signs to 50% of their original brightness. Citizens continued to express dissatisfaction with the situation and requested dimming and/or complete shut-off at night. Art.com was unwilling to turn the signs off completely at night, but stated that it could dim to 35% of the original brightness between 10 p.m. and 5 a.m. The Planning Commission then held an informational item at your last meeting, August 23rd, where a number of citizens voiced their complaints to you. The Commission then scheduled this administrative item for today to consider the order before you. Staff has visited one of the residents' apartments and taken pictures. On the left you see when the sign was red, and on the right the sign was actually pink but came out blue. And so at this point art.com had initiated the suggested dimming at 10 p.m. These photos do not capture well that there was in fact a dimming visible to the naked eye, but the photos were taken. And in addition, staff received information that the sign was having technical difficulties within the last 48 hours and visited the Shorebird Park just before the building and took a video. Unfortunately, this computer is unable to play it, but the sign was cycling through 3 or 4 different colors, not even completely at once. It was kind of a grid pattern. It was clearly having technical difficulties. So that lasted, I understand, about 36 to 48 hours and ended sometime this afternoon. At this point, I'm going to turn over to Ben Stock. Thank you.
Good evening, Commission members. My name is Ben Stock. I'm assisting the city with this action. So before you tonight is the relevant language of why we're here tonight. We're not here to decide the merits of whether or not the sign is operating as a nuisance, but whether there's evidence that there might be a nuisance occurring and whether the Planning Commission members want to institute an action to either revoke or modify the permit that was issued for the sign. The relevant language is found in section 9.492.3, which states the permit may be revoked or modified for cause if the following grounds are found: that the permit was obtained or extended by fraud, that one or more of the conditions upon which such permit was granted have been violated, or that the use or facility for which the permit was granted is so conducted or maintained to be detrimental to the public health or safety or as to be a nuisance. And in the order tonight, you have to identify those grounds of what those grounds might be. So as I'll walk you through, tonight we're not talking about the first bullet point, that the permit was obtained or extended by fraud, but instead that one or more conditions upon which permit was granted may have been violated, and furthermore, that the permit may be operated as to cause a nuisance. The condition in their permit that was approved by the commissioners says, compliance with the municipal code is required and the general plan. No part of this approval shall be construed to be a violation of the Emeryville Municipal Code or the general plan. operations on the site shall be conducted in a manner that does not create a public or private nuisance or otherwise violate the Emeryville Municipal Code. So as you see, there's two alternative bases to revoke or modify the permit. If the permit is creating a nuisance, public or private, not just a public nuisance, or violates some other provision of the Emeryville's Municipal Code. Under the performance standards of the code, the code states under light and glare for nuisances, flickering or intrinsically bright sources of illumination shall be controlled so as not to be a nuisance in residential or commercial districts. So staff's position at this point is, from the data that we have so far, there may be the intrinsically bright source of the sign may be in fact violating this section and moreover may constitute a nuisance under the general law of nuisance. But as you can see, all the facts need to line up with the law on nuisance and whether or not a nuisance is in fact being created. A nuisance in the California Civil Code is anything which is injurious to the health, including but not limited to, and I'll read you the most important parts, obstruction to the free use of property so as to interfere with the comfortable enjoyment of life or property is a nuisance. So the evidence we have to date suggests that there may be a nuisance occurring by the output of light from the sign, and this is the general statement of law of what nuisance is in California. California law also provides what a public and private nuisance is, but again, the permit condition requires it not to be a public or private nuisance, so it doesn't matter which one it is. But so you know, a public nuisance is one which affects at the same time an entire community or neighborhood or any considerable number of persons, although the extent of the annoyance or damage inflicted upon individuals may be unequal. And a private nuisance is everything else. These are the factors you look at to establish a public nuisance, and really the first two factors are only first factor is what you look at for a private nuisance. But for a public nuisance is whether or not the condition interferes with the comfortable enjoyment of property, whether the condition affects a substantial number of people at the same time, and an ordinary person would be reasonably annoyed or disturbed by the condition, and the serious harm outweighs the social utility of the conduct. At this point, from the evidence that we've gathered, we think there's a possibility that these four factors are present, and certainly the first factor, that there interferes with the comfortable enjoyment of property, could be present. After we issued our staff report, Art.com came up with a potential settlement where they would agree to dim the sign by 35% from brightness from 10 p.m. to 5 a.m. daily, and it's currently in effect, but that's not a stated condition of approval, and change the color during the day instead of at midnight, which is new. While we think these steps go a long way in helping with the potential nuisance that exists at the site, the staff also wanted to have the 35% dimness happen upon darkness, not at 10 o'clock at night. There's evidence in the record that a lot of residents are bothered by the brightness when they're going to bed, when they're at home after work, anytime after dark, not some arbitrary deadline of 10 o'clock. And then one of the things that one photo showed you was there is a difference of color. So the other suggestion we asked Art.com to do is to require the red to be used rather than the pink or any other color, and that red blends in a lot more at nighttime than with the other signs in the neighborhood than some other color. So I'll let Art.com talk further tonight because I believe they might have some additional settlement potentials that they're willing to throw out there, but to date, this is what we have from them, and this is what we've been asking for. So for tonight, the potential actions you could do are do nothing, let the existing Art.com sign permit stand as it is with no modification. You can accept Art.com's proposal that they gave you as part of your staff report, and which they'll be presenting some further conditions. You can continue the item to the next meeting in order for more time for the parties to keep talking about a potential settlement, or you can issue the order that's attached to your draft, which is attached to your agenda. And that order would then set an evidentiary hearing at a special meeting, November 1st, where we and Art.com would put forth evidence of whether or not, in fact, a nuisance does exist. With that, I'm going to turn it back over to Arlie. Okay. That concludes staff's presentation.
Would the applicant like to come forward?
Good evening, Commissioners. My name is Doug Akins with the law firm of Hopkins & Carley, 200 Park Avenue, Palo Alto, California. I'm representing art.com, and I think the basic news I have to deliver is good news in the sense that the process seems to be working, and I think you'll find that art.com has acted in a way that you'd want responsible corporate citizens to act. Upon learning of the problem, we immediately investigated the technical issues involved, the electronics, the feasibility of various adjustments to the sign, and right away dimmed it, which was feasible, to 50% brightness. By the way, I should ask, do I have a time limit?
No.
Okay. So while it was dimmed to 50%, we considered the limits of dimming. What are the technical issues involved in dimming it further? It turns out that dimming it below 35% of its original design brightness induces a random flickering and color change among the zillions of little LED lights, and it can't be controlled. So there's a technical threshold below which we can't dim it. As you know from the history involved, art.com has played by all the rules, followed all the procedures, twice gotten approvals based on findings of no annoyance to neighbors, and invested $750,000 in getting this sign up there. It's crucial to the commercial mission of art.com as a business to advertise its presence. It's an online business. The more people who recognize the name, the more people are driven to the websites and the retail outlets. It's perfectly consistent with Emeryville's general plan and zoning. It's one of the good things about being in Emeryville. It allows art.com to get its message out to thousands and thousands of freeway users every day. But our proposal that the staff has referred to, which is a reduction of brightness to 35% between 10 and 5 a.m., we've continued to work on that up to today, and have a new modification to that proposal, we think a substantial enhancement. I'm here to provide this proposal and ask that you direct staff tonight to propose an agreement embodying that proposal and bring it back to you for approval at a later hearing. The rejection of this proposal tonight would terminate the proposal and would be back to this relatively prosecutorial, expensive, legalistic process. But we can terminate that process tonight, and it's art.com's desire to terminate it on a negotiated basis. The proposal is that we would permanently reduce the sign to 35% of its design brightness every day, and the dimming would occur on a timer, be completely automated, 1 hour after sunset. And that's for technical reasons again. As you know from just general orientation, that building sits out there in the middle of a bright sunset, and if you dim it as the sun sets, you can't see it at all. But if you dim it an hour after sunset, you can see it for that duration while the western sky is bright, and then after sunset, it can be dimmed with no diminution of its functional, essential purpose, which is to be visible at night, for goodness sake. So that's the proposal. We dim it every night, 1 hour after sunset, to 35%. Any color changes would occur only during daytime hours. The staff's most recent notation that they would like dimming to be deep red during dimming, I don't know the technical merits of that, and I'm not authorized to negotiate on that issue. It's new to us. But if you accept the proposal and direct staff to work out an agreement, that technical issue can be incorporated into the agreement and responded to accordingly. It's a simple proposal. It's one that terminates the expense and bureaucratic hassle of continuing in a revocation proceeding. I think we've made clear in our previous correspondence that this is not a nuisance, public or private, that it does not affect sufficient people. Mere irritation or annoyance is not a factual basis for a nuisance determination. Nuisance determinations require a balancing of interests, and the commercial interests involved are substantial, affecting not only art.com, but every other business establishment sign. We think we've approached this in a constructive and good faith manner. Our proposal embodies a 65% reduction in the brightness of the sign every day, every night, at a time when both the neighbors can not be bothered by a bright sign in a black sky, and it takes care of the fact that this is a sign struggling for visibility on a freeway in the middle of a bright sunset. As the annual calendar changes the occurrence of sunset, the timer would keep up with that. So there would not be a out of phase condition. I don't want to go on forever, but I think you understand our position. We want to meet the city more than halfway. I think this will be a substantial victory for the neighbors. It certainly will accomplish the crucial purposes of the sign. And this is a sign to which Art.com has a vested right based on its $750,000 investment. We would like the city to accept this proposal, the commission to accept this proposal tonight, direct staff to bring back a one-page, two-point agreement for your ratification at a later date, and ask that tonight you do not instigate a revocation proceeding. Evidentiary proceedings like that are an administrative trial. They're legalistic, they're expensive, they're time-consuming, they're a hassle, and they undercut the essential purpose of our good faith negotiation and bringing to you this settlement proposal. I'd be happy to answer any questions you have.
I have a question. So, in your presentation, you stated that your proposal is that the sign be dimmed 1 hour after sunset.
That's correct.
And your letter, I believe, stated at 10 o'clock.
The letter was then. This proposal is now.
Okay.
We worked it out this afternoon. This is our final proposal. It's our best proposal, and I think it accommodates all the interests.
Does it and does it differ in any other way from the letter that we received?
Not to my knowledge. It's automatic, everyday dimming at 1 hour after sunset. Color changes during the day exclusively, and while it's not dimmed, it would be at its design brightness.
Would it stay one color all day long, or would it change colors during the day?
It would change colors during the day, consistently with our permit. And during the daytime, we're unaware of any complaints. Yes, the permit allows a color change. We're unaware of any complaints from neighbors or anyone else about daytime color changes. If there are such complaints, we'll happily talk about that. But that's a crucial feature of the design. It's permitted. The technology incorporated into the sign is intentionally and expensively intended to be able to change colors. If we had a permit that prohibited color changes, we wouldn't have such an expensive sign. But we do, and we have a right to maintain it, and we're going to defend it as well as we can.
But it was only
but the
once
changes
during
would
the
occur
day.
only during the day, and only in
Only one
accordance
time.
only in accordance with the permit conditions.
And you said that you're not authorized to consider whether the evening color would be a consistent dimmed red color, right?
That's correct. I'm not authorized in the sense, so the staff's proposal as of tonight in those details is new to us. Our proposal is new to the staff and to you. If you direct staff and Art.com to work out an agreement embodying the central features, which is dimming an hour after sunset, one color change during the day exclusively, then I think we have an agreement. We can bring it back to you for your consideration, and we're done.
I have a question. So just to confirm, are we talking, your proposal is talking about both signs or just the north-facing sign, just to confirm?
My understanding, and I can't say this definitively from Art.com's perspective, but I think it's both. In our letters, for example, we define both signs on both faces as the sign. Now, I don't know technically whether you can regulate one sign differently from another through, with electronics and timers and what have you. So it would be at least the sign facing east and facing the residential building. Whether it's the other one, I simply don't know on a technical basis.
I have a question for Kevin.
Sure, and let me just introduce myself. I'm Kevin Siegel. I'm serving as counsel to the board commission in this to help guide in your advice and separated from any role that the city and Mr. Stock has in asking for the prosecution of this or in the pursuit of settlement negotiations, just to make sure everybody understands my role. So, yes.
It's my understanding that we do not have the discretion to accept this deal because it would be in violation of the Brown Act. Is that true?
What I would say, and we spoke about this briefly, is that I think you can give direction and comment on it, give some impact and insight. I don't think that at tonight's meeting you could import or create any terms to the agreement. So I think that I wouldn't go so far as to say you accept the deal, but I would certainly say you can provide some input. You think this would be good or not good, or with modification, and give direction to staff to work it out, and then if they can work something out with art.com, bring that back to you for an actual approval.
Okay, but we do, okay.
So,
yes.
right, so you can give direction, comment, you can talk about it certainly, but you can't take formal action because it's not part of the notice is in order to create any modification to the terms. So you could not modify the permit tonight, but you could give direction as to what you would like to see or the party has tried to achieve as far as a modification to the permit that then they could bring to you, present it as a revised permit, and ask for your approval of that.
Okay.
So that would essentially be a continuance with some direction.
Well, yes, it's a bit like a continuous with directions. It has to come back if you want it for approval. You could also, it's within your discretion to say we don't want to, like you're suggesting, the city to commence the enforcement action, or you could ask the city to, yes, we think you ought to commence the enforcement action and simultaneously try to work on a settlement. So you have lots of discretion as to what you can do and how you want to give direction as how to proceed. But the only point I was making is that you can't make a decision on what the permit should say tonight.
Through the chair, if I may, our analysis of the Brown Act issue is identical to what you've just received, and our proposal is formatted the way it is for the very reasons spoken by your special counsel. The two essential ingredients of our request tonight are, number one, give direction to staff to prepare an agreement along the lines that I've enunciated, and number two, not to order an evidentiary hearing and continue with the prosecutorial aspect of this. As special counsel mentioned, you can either order the evidentiary hearing and continue to talk settlement, or you can refrain on the evidentiary hearing and continue to talk settlement. From our perspective, obviously, we've spent tens of thousands of dollars and untold time and effort in trying to get to this compromise point. Continuing forward under the threat of revocation proceedings and evidentiary hearings and what have you simply translates as a lot more money, time, and hassle. You have the option, obviously, of directing staff to pursue this agreement along the lines enunciated, and if you don't like it, reinitiate it. Go back and at that time order the evidentiary hearing. So you lose nothing by stopping the administrative prosecution proceedings. Thank you.
Thank you.
I have a question.
One more question for you.
So this can be programmed so it changes modes 1 hour after sunset. I'm assuming it can do the same thing 1 hour before sunset. That would be technically capable?
I'm not a technician, but I've been impressed with the amount of control that is permissible. The answer to your question is probably yes, but I don't know that for certain.
Okay.
Put it this way, it's put on a timer. And the timer keeps up every week or 2 weeks with whenever sunset occurs, and it automatically adjusts the time when it dims the lights.
Okay. And there isn't anybody here tonight that can answer more technical questions?
That's correct.
Okay.
I mean, I'll try, but
one of the questions I had is this sign is made up of an array of pucks, I think they term them, of LEDs. And what I'm wondering is, these pucks are, say they're rated 500 watts. Is it possible to replace the puck with a 25 watt?
in concept, it probably is just on a common sense basis, but on an equally common sense basis, what you see there costs $240,000. And we'd rather tinker with the electronics than replace the entire thing.
But there are limits to, at 35% of
Yes,
total brightness.
that's the limit.
It limits, it drops out.
We run into that wall
Right.
of how dim we can make it.
So I guess where I'm going is that if you use a smaller wattage to begin with, you would have more control over those limits.
That's probably true, but at the risk of the sign's essential purpose. I mean, it sits high up on a tall building for the purpose of proclaiming a commercial message to thousands of people. If it's dimmed to the point where it's invisible, then it's worthless.
And it has been running at the 35%.
From 10 o'clock on, yes.
And
If you were to get direction to negotiate that agreement, whether it's with the red at night or not, when would you start implementing it? Because part of our problem is that we didn't have a clear understanding what it was going to look like before, so we don't have a clear understanding what it's going to look like if those terms are gone forward.
Certainly. And again, I have no authority to negotiate unanticipated details, but I can predict that as soon as an agreement is reached and approved by the city, we would implement it immediately.
So you wouldn't start testing it so that people could see whether that actually accomplished the purpose?
We've already done that. We started testing it back when we alluded to testing it in the letter, and now we're satisfied that at 35% it's working. It's accomplishing its purpose.
I want to make sure I understand the history of the dimming of it. So when it was first installed, obviously it was operating at 100%, and then at some point it was dimmed to 50%.
That's right.
And now before 10 o'clock it displays at 50% of its original brightness, and after 10 o'clock it displays at 35% of its
That's
original
correct.
brightness.
That's correct. So what you're seeing is what the staff showed in the pictures was that 15% dimming is not necessarily all that glaring, and that's not obvious. Well, put it this way, it's obvious to the naked eye, but not so obvious to a camera. I think it'll be obvious to the residents because it used to be 100%. And a 65% reduction in brightness is a substantial reduction by any standard.
And it's been running at 65% for how long again?
At 10 o'clock, it dims to 35%, which is the 65% reduction.
But how many
How many days has that been?
days, weeks?
I couldn't tell you for certain. I don't know. But
More than-
let's say a week
more
or
than a
two.
week?
Yes,
Okay.
something like that. As we have tinkered with the electronics to see what can be done, that has been the regimen.
September 6th.
Council says that it was probably set to September 6th,
Okay.
but I don't know. Thank you very much.
Questions?
I'm wondering if it's possible to ask staff about their observation of the sign.
Sure.
Maru?
Are you,
I think Arlie Cassidy should be in a position to answer that question.
Hello, Commissioners. So I visited Lori Carson's apartment, I want to say on a Thursday and a Monday after the September 6th implementation of the dimming at 10 o'clock. So the Thursday visit was the red and the Monday visit was the pink. And I took a number of pictures both before and after from 2 different apartments, outside and inside, and viewed it as thoroughly as I could. The signs dimming is not something that you, or that I, or to my knowledge, Lori has seen happen, and it's not a specific kind of chunk down as you're staring at the sign. But when you look at it before and after, you can tell that it's dimmer, and that's primarily by comparing it to the signs adjacent to it. The Holiday Inn sign, it was especially easy to compare on the Thursday when it was red. The Holiday Inn sign obviously is the same dark red, and it was noticeably brighter before the 10 o'clock and then seemed about the same brightness after the 10 o'clock dimming. The pink is a very different type of color, so it also strangely had that kind of pink and blue combination, so it's harder to compare brightness to the red, but there was still a noticeable dimming between before and after 10 o'clock.
So did it, I mean, it supposedly dims 15 additional percent. Did it seem approximately 15%
That
dimming?
sounds approximately right. Any other questions?
Okay. Although this is an administrative item, I would like to open up the floor for public comment. If anyone would like to comment, please come forward. You have 3 minutes to speak, and then please sign in afterwards once you're done. Thank you.
My
My pardon, I forgot to mention that the 2 letters that were emailed to you earlier are also here and printed, so if anyone wanted to see letters from the residents, which we also have on the dais, the copies are here. Thank you.
Thank you.
Hello, my name is Lori Carson. I've been before you before. I heard the buzz in the elevator about the sign when it was first at 100%, and
Could you pull the mic down a little?
you've
Thanks.
told me that before. Thank you. Can you hear me? And, you know, I just heard so many complaints, I decided maybe we should gather together, and we did call a meeting, and obviously we have quite a large contingency here of residents in the Pacific Park Plaza building. We have all kinds of different viewpoints about what we would like to see happen. There are many that, of course, want it to just disappear and be gone and take it down, take both signs down and not have Emeryville marked or branded by this sign. I certainly started out with the intention of hopefully working this out in an amicable way. As I told you, having been from a family of lawyers, I am the least litigious person you would want to meet, and I didn't want to have some kind of a negative kind of situation here. I really want to work it out. We feel a little bit like we're dealing with Goliath, you know. We're just residents saying, hey, it's affecting not only the quality of our life, which is one of the conditions that we feel is being violated here, but also we do have some health issues in the building that are also a problem. So we do think that there is certainly evidence that we should have this hearing take place for a modification revocation hearing. I know that they had some kind of a problem with the sign, and it was flashing colors for the last couple of nights, and it did that before on June 29th. And it was interesting to me that it wasn't fixed immediately, especially knowing that we were going to be meeting here, and I thought, you know, they probably don't see it. They have 1 floor of the building, not that many employees, but you know what? We not only saw it, it affected a lot of us, and for me, I couldn't escape it. We have 1,100 square feet of living space. There is no window in our condo that doesn't look at the art.com sign. And it isn't that we're singling that particular sign out. It's that the Siebel sign was a very graceful 1-line sign. It was backlit. You can't even compare it to an LED sign, and truthfully, we don't really care what the illumination was. There was never a complaint. This is the first complaint I've ever had, having lived in PPP for 20 years. I've never had a complaint before. The 10 o'clock dimming, I'd like to address that. At 10 o'clock at night, the LED sign still reflects light into our condo, enough that for my grandchildren, I can do hand puppets, shadow puppets on my wall. The light that comes into our condo is only from the illumination of this particular sign. It bounces off the right-hand side of our main window because it's a white building, and so it reflects. And I think those of you that have come have seen it. My time's up. Sorry, there's plenty of others. Thank you.
Thank you. Please sign in.
Hi, I'm Chris Owens, and congratulations, Vanessa. Aren't you lucky that tonight is your first night as chair? And I am a resident of Pacific Park Plaza in Unit 1927, and I am not affected by the sign. And I guess I got really lucky because 27 years ago, when I looked at Pacific Park Plaza to buy a unit, I wanted my floor plan with the San Francisco view, and I couldn't afford it because it was $100,000 more. So now I live on the other side. And so I wonder if this garish sign does what it does to the real estate values of the people with the San Francisco view, and how it affects them. I have several other things I want to say. Art.com is contending that they're leasing the sign and that it's costing them $750,000. Well, we have over 200 units affected by it. We have 35 corner units, which are the more expensive and penthouses, where each of them has a value of about $750,000. So the total value just of the expensive units that are affected by this is $25 million. So don't give me $750,000. Art.com also contends that their sign is no brighter than the previous Siebel sign. Well, that is just totally ludicrous, because never, ever was there a peep out of the building. As a matter of fact, we're really, really good, reasonable people, and we value our businesses, and we were really proud to have Siebel in town, and we were sorry that they got swallowed up by Oracle and left town. So finally, Art.com states that we're denying them the right to advertise their business. Actually, we're not, because we do not have a problem with the sign on the south side. So, which frankly gives Art.com a much broader exposure to the freeways than the north sign. Because everybody right now with the north sign that we object to, all they get is the people coming down Highway 880 in the morning to go to the city. The other sign gives them all of 880 coming back at night, and it gives them all of 580 east and west coming to and from San Francisco, being stuck in the bumper-to-bumper traffic, and they get an absolutely fabulous exposure. Not only do they get all of that area, they get all of West Oakland and probably all the way down to Jack London Square. So, wow, you know, that's like $1 million advertising exposure. So why do they need to have a sign on the north end and invade the tranquility of our homes? Thank you.
Is there anyone else that would like to speak?
Good evening, Madam Chair, Commissioners. My name is Harold Jones. I live on the 29th floor at Pacific Park Plaza, directly across from the Art.com signage, both in direction and also visual height. And I'll admit that seeing an unusually bright, shining neon light that wasn't there before, suddenly in the sky, it takes a little bit to get used to it. And eventually something like that begins to visually blend with the background, and you do get used to it. In fact, when my neighbors started complaining about the sign, I kind of hesitated to weigh in, thinking, I'll get used to it, and they will too. Unfortunately, that's not been the case. The colors go way, way beyond illumination. They change constantly, and sometimes they glow at night. Now, those pictures didn't really do justice, but I invite you to come to my unit. Well, I won't say that, but come to my unit at 9:30 and you'll see, even like at 3 o'clock in the morning, it literally glows. And it may be certain colors that do that. But on August 24th, the Commission approved this sign with some specific and I thought very thoughtful conditions, all of which made sense to me. The question now seems to be whether or not this sign violates any civil code that would determine it to be a public or private nuisance. And I don't honestly know that the impact of this, on me at least, could legally be defined as a nuisance. But if Art.com claims to be voluntarily dimming the sign, it's not obvious to me. And in fact, almost adding insult to injury, it just seemed like yesterday was an odd day for the sign to suddenly begin this non-stop flashing animation. But it may be determined that no civil code has been violated. But I'd like to share something that is being violated. And this is really interesting because the violation happens to be something that ironically is prominently displayed on Art.com's own website homepage. And it seems to put this whole issue in a greater perspective. And I encourage the attorney who represents Art.com to think about that as he advises his clients. While there may not be a legal violation, this violates the precept of Art.com. It says on their website, when you hang a piece of art, its impact isn't limited to just the space between the frames. It has the power to fill the room, change the mood, and affect everyone in it. And when you find the art you love, you'll love your space more. We believe art is dynamic, personal, and connected to now, and the experience of living with it should be too. Emeryville, that's Art.com. So we applaud Art.com's view of that, but Emeryville is viewed by so many as a perfect meld of business and community. And the Art.com sign is art, I guess. And as they themselves espouse, that sign is not limited to just the space on that building. It's the space around the building, below the building, across from their building. It fills our community. It changes our mood. It affects us in many different ways. We welcome art.com and the contribution that they're going to make to the city of Emeryville and our community, but we also believe that art is dynamic, it's personal, it's connected to now, and our experience of living with it should be too. I urge the Commission to carefully consider the residents' views, the surrounding community, and I'm available. I would volunteer to help in any way I can. I used to be with the Port of Oakland, and I dealt with the 3 billboards that have LED signage. I mean, we got lots of complaints, and there are things that can be done. But I just urge you to consider the views of the residents and the impact that it is having. While it may not be a legal nuisance, it does violate our rights. Thank you.
Thank you.
Good evening. My name is Paul Gerhardt, and my wife and I live at Pacific Park Plaza. We've lived right in front of the art.com sign, but not by our choice. I've spoken to you before at your last meeting, and I have spoken in front of the City Council. Several members of the City Council and the Planning Commission have come to our home to see the art.com sign for themselves, from my 2 bedrooms, from my living room, from my kitchen, and even from my bathroom. I am sure by now you all know how we feel about the sign, but now it's affecting my health and it's affecting my wife's health. We're unable to sleep at night because of the light intrusion. As tight as we try to close the Venetian blinds, it just shines through. We wake up at night with severe headaches. There's no way to escape the effects of the intrusion of this light that comes into every room of our home. We're concerned about our property value is down now because if we wanted to sell, we're going to have to disclose this light intrusion to any buyer. These issues could become litigation issues for us in the future, but I really hope not. No one consulted us before the sign went up, and hundreds of us now live right in front of the art.com sign. There have been a lot of words to describe the art.com sign, but one word seems to stand out best to describe the art.com sign, and that word is mistake. I've heard that from individual members of the City Council. I've heard that from members of the Planning Commission. I haven't heard anyone from City Hall support the sign. The art.com sign is a mistake, and I think most of us agree with that by now. There's been talk about trying to dim the sign, but here's what I've seen from my home. The sign is dimmed a little bit around 10 p.m. But depending on the color of the sign, the dimming has little or no effect. But around midnight, the sign changes color and returns to full brightness for the next 22 hours. Dimming the sign is totally ineffective and is not a solution to this problem. Our property values and our health are at issue here now. I think you need to do the right thing tonight, and we need to correct this mistake. You need to make a decision in favor of hundreds of Emeryville residents, not an internet poster company. The art.sign needs to be removed. There'll probably be threats of lawsuits or whatever, but you have a city attorney to deal with that issue. I urge you to issue an order for removal of the art.com sign. Thank you.
Is there anyone else wishing to speak on this? Come on up.
The next person waiting to speak can form a line behind them so that it moves along.
Charlie.
Hello, I'm Stanley Haig. I also live in PPP. I've spoken to this group and to the council before. I I think that those who have gone before me have been very eloquent. I wanted to address, I don't want to cover the same ground. I just want to really emphasize some of the criticism I have of Art.com's response to this brilliant catastrophe. One, they have frequently, continually support the decision for this sign by pointing out that it's merely a replacement for the old Siebel sign. That the Siebel had a sign, an illuminated sign. We have taken over their premier position in the building, and we deserve an opportunity to show our sign. And their claim in their written document that was circulated that this new sign is demonstrably no brighter than the Siebel sign. Others have said this is just totally inaccurate. The Siebel sign was a subtle backlit sign that blended in with the color scheme of the building. This building is one of the most beautiful buildings of its size and purpose that I've ever seen. It's a gorgeous building. It's the best looking building in Emeryville. It had a sign that was elegant and understated. And ironically, if you go to the website, the Art.com website, they proudly show a picture of 2100 Powell Street. And what did they show? A daytime picture with a faint sea green version of the Art.com sign. So they even recognize that the sign, in that one example, they're emulating the old Siebel sign. It's very, very disingenuous of them, I think. I wanted to say something else about this sign. Excuse me, I don't like public speaking at all. The issue of whether or not fraud is at play here. That's an awfully strong word. I don't really have as big a gripe with Art.com. I have a few gripes. Their claim that this sign is not brighter than the Siebel sign, etc. But my complaint is with the Young Electric Sign Company of Salt Lake City, the designer and manufacturer of this sign. Art.com shouldn't be expected to be experts in this sort of new technology. You shouldn't be thought of as experts of this type of technology. The planning staff aren't experts. If anybody's responsible for this catastrophe, they knew or should have known how bright and intrusive this sign was, and by not letting us all know, they are the ones who are responsible, and they ought to be on the hook for it. They ought to refund, and they ought to take it down, give them a better sign. We ought to go through the whole permit process again now that we know what we're really facing. And they should move this sign to the we should move this sign to the Columbus, Ohio site for Art.com.
Thank you. Is there anyone else wishing to speak? Come on up, and then if there are more people, come on up and wait in line so we can hear you efficiently. I know there's lots of folks still, probably.
Hello, I'm Brian Gross. I live at Pacific Park Plaza. I've lived there for 27 years. I've spoken to this group before and the City Council. I'm a lifetime art dealer, and I have a gallery in the city, and I've been involved in art and architecture and public art projects all of my career. I don't want to repeat everything that's already been said, but I'll just summarize it. The basic problem is the sign is a mistake. I think that the city inadvertently entered into something that they didn't know. They did not know exactly what they'd be getting. I think there are issues of the technology that were not worked out. No one knew what the impact would be of this electronic sign. Looking back through documents of the process, the evolution of the Art.com sign, at one point in the original version that was approved was Art.com all on one line, and it was closer to the size of the Siebel sign. What is there now is a gross exaggeration of that, and it is more or less a billboard. It's intrusive, and I also am very worried about how it will tag Emeryville, deflate home values throughout Emeryville, not just our building. But the thing is a problem, and I think that this group has an obligation to really fix it. So I hope that you can get there. Thank you.
Hello, my name is Reza Ilkhani. I am a 12-year resident in Emeryville and Pacific Park Plaza. I want to echo the issue of mistake, but from Art.com's perspective. Let's say if I were one of the executives of Art.com. It was a mistake with respect to the commercial and marketability of the sign. It is an extremely unattractive sign. What is the data point for it? Look. There has never been any other complaints to any other signs. The parts that makes it really unattractive are the colors and the luminosity and also the font size. So if you compare the Art.com sign, look at the A or any of the letters in the Art.com sign compared to Hilton. It's much bigger and they stack it on top of each other. So you're looking at a font size that's exponentially bigger than the other signs. So that's point one. The second point is that they spent so much money on the luminosity, but it's really been a waste of time. You can't really see it if you're driving from University Avenue. It's just one big, it is one big blur, so it really can't be seen. Secondly, what is the advertisement value? They are an internet business model. The people who commute along the 80 are the same group of people. If you change the color to blue, to a pink, to a yellow, they're not going to buy more. So those are the mistakes with respect to the advertisement itself. The second thing is once you engage a battle, you really need to look at the consequences of your dispute. So first of all, it's going to have a lot of diverted resources for Art.com where they could spend on pushing their business forward. Secondly, they will create, they will disenfranchise, they will divert a lot of the potential customers if the word gets out that there is this corporate entity fighting with a group of residents. And obviously an art entity wouldn't want to have that image as well. Okay. Thank you.
Thank you.
My name is Mitra Latifi. Although my unit is not facing the .com sign, but I've heard from some of my friends who are facing the sign, and they have told me that overnight when they're sleeping, they have to cover their eyes in order they be able to sleep. And that is something to consider because that's the nighttime. That's a piece of your home, and you want to relax and enjoy the night. To make the story short, I would like the way I'm hearing everyone talking. And first of all, thank you for the excellent presentation of the people and precisely definition of the nuisance, which was very educational. I appreciate that. And the way I'm hearing everyone is just that you all are looking at the human being's comfort and peace of mind versus $750,000. The decision is yours, but it seems pretty simple and straightforward. Thank you for your time.
Is there anyone else?
Yeah, I'd like to speak. So I'm looking here at the packet about this Art.com sign issue, and I see just a huge amount of human effort. A lot of money's been spent by the staff here. Just like many, it's half an inch thick of city employee work on this issue. And then here I see just page after page of people signing a petition against the Art.com sign. It's just page after page. It's very dense with signatures from people at PPP. They don't like the sign.
And so I'm just sort of marveling about my town of Emeryville, because in this town we have teachers getting laid off, the school's in crisis, and then we have a school board meeting where they're laying off teachers, and you get one or two people show up that are concerned about that. You get the city council approving favored developers, getting millions of dollars in subsidies from the city of Emeryville to tear down historically significant buildings and cut down trees and to build a project that doesn't that needs that's against the zoning ordinance. You'll get a couple of people complain about it. But when you get a sign that can be seen from Pacific Park Plaza, well, you get a full house, and it's upsetting that I live in a town like this where you get the priority seems sort of skewed. I think that if enough people don't want the sign, well, I don't think we should have the sign. But I just sort of wish that some people that are here tonight would show similar passion about issues that really matter in our town. It's just sort of upsetting to me to see this amount of effort for this issue. Thanks a lot.
Thank you.
My name is Gabriel Basso. I am a resident and an owner at Pacific Park Plaza. How much time do we have, by the way? Is it
3 minutes?
3 minutes and the clock started already?
Yeah.
I'll try to be quick. A lot of the folks that spoke before me, I think, raised a lot of great issues and points that I would have made. I appreciate your comments, by the way. I don't know that I would trivialize this or suggest that it's any lesser of an issue, but I think you made some great points. I'll try to bullet point through just some of the things that I've noticed. The predominant thought that's gone through my mind as I, kind of thought about coming here to speak was asking people where they live. Where do you guys live? Where do the owners of art.com sign live? I think the other gentleman that went to their website to understand their perspective on art made really good point. But what I would emphasize is this sign is outside the window of our home. And it blasts its light right into my bedroom. It is affecting my ability to sleep negatively. That's not good. I bought this unit because I love the view. And I think the points that were made, that were brought up from art.com's own website about their philosophy and their ethos about art are so ironic and so completely compelling that I think you guys have a lot of good information. Going through this packet of information that they've prepared, there's a lot of stuff that I think is factually inaccurate. For example, they say in one section here, the formal proceedings proposed are unnecessary, arbitrary, and a poor precedent, allowing a few subjective complaints to jeopardize expensive and important and perfectly legal permitted advertising. That might be conceptually accurate, but it's factually inaccurate. I'm a commercial banker, and I can appreciate their capital investment. Previous speakers pointed out that the capital investment we've made into this property on our side as our primary residences, some of the biggest investments we'll make in our life, might also be taken into consideration. I don't see that mentioned in their argument. There's probably a lot more to bring up that I can't really outline. I was listening to the news last week on NPR driving to one of my appointments. Highway 85 down near Sunnyvale is repealing a sign because it's too bright and it's distracting drivers. Imagine if it was blasting into the window in their home. I really want to emphasize this, and I think that if the art.com, the owners of that sign, want to put this sign outside of their bedroom window, that's fine, but it still doesn't mean that they would have my permission to put it outside my window. I didn't ever see the Siebel sign. I don't really see how that's relevant. I think one thing that they said in here that was very relevant is the impact that it would have on the business community, and I think that is a very fair point to make, but I don't think that encapsulates the entirety of the situation. And so even though I think they make that point about the city council having to be fair about the message they'll send to the business community, which I think is a very legitimate point to make, I hope you guys know that you are following a procedure, and there is merit to what we're saying. Thank you for your time.
Thank you.
Hello, my name is Michael Millman, and I'm a resident at Pacific Park Plaza.
I've lived in the building for 10 years, first on the 27th floor, now on the 30th floor, and the art.com sign is literally right outside of my window. I share every concern that other residents have mentioned, and I wanted to mention something myself from my perspective, that is what I think is important. If you bought something and you enjoyed inherently the view that has substantially changed after you moved in, you didn't see any of the deliberations or the process or hear about any of that when it was being promulgated. And you have to deal with what we have to deal with right now, coupled with looking at that sign when it starts flashing all over the place. It looks, I mentioned this before, the City Council and the prior meetings, and it makes Emeryville, to me, feel like vaudeville, okay? And I don't like that. I really don't like that, because I live here, I pay taxes here, I have a business here, and I own multiple properties here. There is no doubt in my mind that our property values have been negatively impacted. Period. End of story. I've spoken to 3 different realtors about this that I work with on a regular basis. I am not anti-business, and I really think that a careful balancing of the interests here, you have a task in front of you, which I know we all appreciate. I just want you to think about it from a resident's perspective, and also people who are here in business, paying taxes and property taxes. I'm very upset about this sign, and I know that you guys are going to make a decision that supports the best interests of Emeryville and all the parties involved. Thank you very much.
Thank you. Is there anyone else wishing to speak? Seeing none, we'll close the public comment. And so what we have before us is a decision to either adopt the resolution to initiate action to revoke or modify the permit or not. Would you like to start, John?
Sure. Thank you for all the people that came out here tonight to really talk to us about this and what you're experiencing. And also thank you for the people that invited me to their condos so that I could experience it, which was very helpful for me. So when I did that, I experienced 3 things. The first is that, and I ultimately I do find this to be a nuisance. I approved this sign when it came before us, and I really didn't know the impact of how bright these lights would be, how obnoxious this sign would be. Had no idea. This is an emerging technology. Had I known it was going to be anything like this, there was no way I would have approved this. So the issues that I really saw are 3 different things. The first is the quality of the light, and the quality of an LED light is totally different than the quality of a backlit sign with plastic lettering that's translucent. It's totally, very much different than a neon sign, which has a gentle, warm glow to it. I would term the quality of light as glaring, I think is really the word to use, and harsh. If I could describe this as a sound, I would call it shrill or piercing. It's a quality of light that's really important here. So when we're talking, when it's been compared with a steeple sign, it's totally different on that account alone. The second is the intensity of the light. It's what I experienced last night when I walked into somebody's unit, and this was about 9 o'clock at night, maybe 9:30, is I could literally see my shadow on the wall from this light. It is extremely bright. I can see the sign from the BART train in West Oakland. I can see it driving down 80 coming southbound. And as other people have pointed out, it has brightness, but it is not legible until you get to about Ashby Avenue. I actually feel that if they dimmed this sign more, it would become more legible and not less legible. So the third thing is the color of the light. And again, last night when the sign was going through its random motions of all kinds of different things, it was actually very helpful for me, because what I discovered was there was a point in the cycle that it went to a deep red. When it did that, my shadow on the wall faded out. And I think that's really important. And I've had several people that I've talked to say that, you know, it's like we've got this big Hilton Garden sign on the building. It's red, it's big, but we don't find it offensive. It's not distracting. And I think that color is a very key thing to it. So I think we have solutions here. I think we can come up with something that works for everybody. But at this point, my feelings are that Art.com has come up with too little, too late. And I'm going to throw something out here for discussions, things that I think we could possibly look at. These are things that Art.com could implement next week. And we could try it and see what the impact is. And maybe we can stop this before it gets too far. But the first thing is, I haven't heard anybody complain about the south-facing sign. So I think we really need to decouple the south-facing sign from the north-facing sign. Let the south-facing sign operate as it's currently operating. One of our conditions of approval was that we wanted the signs to operate together. So I would suggest that we decouple those, let the south-facing sign operate independently. The second is that it appears that this sign has the ability to be controlled on a time-of-day schedule, or even more sophisticated, to track the sunset times. What I'm proposing is that this sign make its mode change from the day mode to the night mode. Instead of an hour after sunset, a half hour before sunset. We shouldn't have to see this glaring, and I mean glaring, sign at sunset. These are people's homes. This is offensive. But I think if we make the transition to a lower brightness before sunset, it'll have make it a much easier transition for the people in PPP. The third thing is to match the color, the hue, and the saturation as close as possible to the red Hilton Garden sign for night operation. And I didn't have time to do a whole lot of research, but I know from my times on boats and boating that we used a red light at the nav table at night because it wasn't jarring to your eyes. And I think, in my experience, when I saw that sign cycle through its brief period of red last night, is that it isn't jarring. So I'd like to try a deep, solid red every night. It goes to a solid red. And then the last thing is to dim the sign at night to 35% of its maximum brightness. I'd like to see it dimmer. I'd like to see the pucks replaced with smaller wattages or the equivalent in lumens or whatever it is. But let's try this. Let's try something like this at the 35% that it's currently capable of. I want to be reasonable with Art.com, but I certainly want to be reasonable with the people that live at PPP. So those are my comments.
Anyone like to go next? Kyrie?
Thank you. So some of the comments that I want to make, I'll start with the first one, which is I'm not really clear why there's a need for multiple colors for the sign in order for Art.com to adequately do their advertising. It seems that, from what I understand, they don't necessarily have a logo that is one color, like some of the businesses that we have here in town. So, and it seems that, as far as the colors are concerned, the way that I've observed it myself, the colors seem to be, some colors are more intense than others, and I've perceived that at least one color that I see on a regular basis is not, it's actually blurry, which is the color blue. It has a halo around it. At first I thought it was my eyes, but I drive by it every morning at 7 on my way to Berkeley, and whenever it's blue, I can't read it. It's really fuzzy. So if I were a driver on the freeway, it might be distracting to see that blue and not be able to actually make out what it says. So I think it's a bit of a distraction for drivers. As far as the dimming effect, if the dimming works for certain colors but it doesn't work for others, I think that there needs to be some more experimentation with making the dimming more consistent so that all the colors are dimmed the same amounts. And I think that's similar to what you were saying about the hue and the intensity, that it needs to be more consistent. Speaking of consistency, I think that the signs that are in the area, such as the red signs, it would probably be a good idea for the art.com sign to be more, I would prefer if it were more that color most of the time, red, because it's more consistent with the signs that we have in Emeryville. And then there's a question of the dimming time. And just sitting here in today's meeting, and I'm sitting across from an open window, and it's now almost 8 o'clock, and it really has just gotten dark. So I think it would be, if I were to be exposed to waiting until almost 9 o'clock until the dimming took place, that would be, I would have an issue with that. So I think that we should explore earlier dimming times. So, and those are my comments.
Thank you. Sean?
I don't have a whole lot to add, but I'll just say a couple of things. One is that I did try to go observe the sign last night, and I tried to get there right around 10 o'clock so that I could see it both before and after 10. Unfortunately, the sign on the north elevation was just freaking out. It looked like a discotheque. It needed some Bee Gees music along with it. And so I did take a little video on my phone, but it doesn't really do it justice. That you can just see the kind of colors flickering in the distance. But it was, I mean, it was clear that it had some sort of computer glitch. So anyway, I was disappointed that I wasn't able to evaluate the brightness of the, I mean, I've obviously seen the brightness of the normal intensity of the sign, but I wasn't able to observe the reduced brightness last night when I tried to. The other thing I will say is that I did speak to a sign contractor that I know, and my question for him was whether, basically whether some sort of plastic face could be put over an LED sign that would diffuse the light more like, more like standard channel letter, well, what we have come to know as standard channel letters, which are usually neon illuminated. And he told me that that was something that could be done. I think in this case we have, this particular sign which changes color. I think that adds complexity to it. But in my mind, I think going, just looking into the future, I think that's, if not with this sign, I think that's something that we should explore with future, at least with future LED signs that come before us, is because to me that seems to be the problem. I think if you have LED channel letters that have some sort of face over them that diffuses the light, I'm not sure that it looks all that different from what the Hilton Garden Inn sign or any of the other numerous neon lit channel letters that we have in Emeryville. And then I was going to say one other thing, but it slipped my mind, so if I remember it, I'll come back and say it.
Well, I'm sort of on the same page with what I've heard from other commissioners, which is that the intensity, I think that there is cause to find that this could be a nuisance to people that are living in PPP, so I think we have a basis to go forward with a revocation. And to me, the question is whether we're moving in the direction where we may be able to resolve this without going through that process. I think that the intensity on the north side of the building is just, I don't think it would be acceptable to me if I were living there. And I think one of the things that is the most disturbing is probably the color changes, because some of the colors are just much colder and much more garish than others. So there have been a number of suggestions, including putting some kind of a shield that would block it from direct vision of PPP, or maintaining it in just the red color and dimmed to the maximum extent from sunset or before sunset or for some time. What I'm sort of grappling with is how to test these things out, because as I said before, the reason we have this problem is we didn't know what it was going to look like before. So we can say, yeah, 35% would be all right from this time to this time, but we really don't know yet. So I think we're moving in the right direction. I think we really do need to get this resolved, and it is a nuisance. It appears to be a nuisance for a good number of residents, whether it's public or private, whether it's legally supportable as a nuisance. That's a factual question that we would have to answer at the next step. But I would like to see art.com. I think it's true that the south-facing sign captures a whole lot more traffic. It sees, more people see it. The north-facing sign is illegible until you get really close to it and seems to be much less useful as an advertising device. So I would agree with much of John's suggestions about leaving the south-facing one as the primary advertising sign and adjusting the north-facing one so that it's not interfering with the residents' enjoyment of their homes.
Well, I agree with what all the other commissioners have been saying. I do think, though, we should follow the suggestion of the staff, which is to issue an order to initiate an action to modify the existing permit. Now, I think that we're going to need samples, or need examples, rather, of what the reduced situation would look like if it's in deep red before we could agree to anything like that. But we need to start this process. And I think by initiating an action to modify the existing permit, we push the action to go ahead. We push something going ahead. And I think that's what we need to do.
Well, I agree with most of all the comments of the other commissioners, and I wanted to add that to me it seems that the ambient light levels would may be a more appropriate measure, and I'm not sure how the process is through measuring with foot candles, and I think that would be a more appropriate measure going forward as opposed to what's being measured now, which I guess is nits, and that's what it says on the specs for the pucks. I believe that's candelas per meter squared or some such thing. Way over my head. In any event, in the evening when the fog, I've been looking at the sign many times, when the fog comes in, it just is this glowing mass, and there's ambient light that is way greater than any steeple sign ever was. And I think I agree that it possibly could be measured against another existing sign nearby. It seems that everyone is pointing to the Hilton Garden Inn, which in my opinion is pretty bright. So that might be one way to go as a measure as to what is acceptable in this case. I also definitely agree with separating the north and the south. I think that's an excellent idea. And I believe, in my opinion, that it is it does qualify as a potential nuisance, and I am concerned about if we do not move forward that things will not, feet will not be held to the fire. And I think that art.com and the staff can still work something out. So I'm very hopeful that could happen while the while this is proceeding. So I'm not sure. Do we have a sort of consensus as to whether to proceed or to?
He wants to speak. I think you can tell him he can't.
I'm sorry, the public.
If I could respectfully just maybe a half a minute to respond to, I ran out of time. Okay, I'll make this brief.
No, I'm sorry, the public comment's closed. So.
This will be so brief, and I promise.
All right.
And I really appreciate the
I have to
exception
reopen
policy.
the public comment. Is that something that's possible to do?
I'll keep it to less than a minute.
I think it's within your discretion. If you want to take some time for
Okay,
brief
I'll
public comment.
reopen the public comment. for you.
Thank you very much. I appreciate your guys' comments, particularly your consideration. The words that concern me are let's experiment with, let's test. Again, one thing that I'll also highlight is nobody suggested just putting up a barrier, almost like a headlight's recessed inside of your reflective shield. They can play with the light all they want. I would also highlight that if you dim a very big light, it's still going to be an intrusion. It's impacted our view, it's impacting my sleep, but ultimately, could we also look into just putting up a shield that will block the light from the north sign and shadow our building from whatever they want to do, and then you guys can experiment all you want.
That was
We
one,
won't
that
have
was
this
one of the,
invading
that was one of the things that we mentioned.
Thank you.
Okay. Now reclose the public comment. And I also I agree that the light is intrinsically piercing, so I think that is another finding that could be made, and certainly the potential for property value decreasing is also. So, comment?
City staff would like to make one more point before you decide what to do. If we move forward with enforcement, adopting the order, it will require staff to pursue simultaneous actions, preparing for the adjudicatory hearing on November 1st, while also continuing to explore settlement options. We just want to make the commissioners aware that it will be an expensive proposition to move on dual tracks at the same time.
And so if we decide to continue this item and
if you
let
decide
them
to
work it
continue
out,
and have the parties continue to try to work something out until the next Planning Commission meeting of October 28th, I believe is the date. We could, is it the 28th? 25th. We could then on the 25th decide whether or not to adopt the order and then set a special meeting for a nuisance abatement hearing. Or you can set it tonight on November 1st and have us march on two tracks at the same time.
I am concerned about the expense and the staff time involved in this, and I think that we have said pretty clearly what our concerns are, and I think that Art.com's representatives probably have a pretty good idea of what may or may not be acceptable and what should be considered. So, I mean, with that consideration, I would sort of favor putting it over one more time with those directions. We're not going to back off, but in order to avoid inordinate expense for everybody involved, I would really rather see it resolved in another manner.
I would really want to see it resolved, though.
I would also support a continuance only because, for a different reason, but only because I was not personally able to view the sign in its dimmed fashion. So, I would really like the opportunity to be able to do that.
I've done some research on LED signs, and there are capabilities to reduce them to 4% during the evening. And so I'm not really certain exactly what's going on with the pucks that they're using, but I think that some more research needs to be made. So here it is before us. We can.
Well, how does staff feel about a postponement to the next meeting?
Maru?
They tend to be positive.
One of our recommendations, that's one of the options before you, is continuing it to the next.
Recommend that?
Our recommendation is to issue the order and modify the conditions.
I'm concerned that time is passing and people are not sleeping. There's that.
Well, I really believe that if we tried what I proposed, I think that's a workable solution. I don't think this is an experiment that's going to fail. And it's certainly going to provide much more relief for people. So I would be willing to continue this, but at the same time, I want them to do something. I want them to take action soon.
His attorney wants to speak.
No, I'm sorry. We're done. Please come forward.
Thank you, Madam Chairman. Just as a point of order on the last issue of the process, if I could comment, a continuance would be extremely beneficial, and I think it's constructive from art.com's perspective. We have indeed, as Ms. Donaldson mentioned, heard a lot of technical information, a lot of policy information, a lot of options. And I'm not qualified to evaluate the technical issues, and blending the different perspectives that each of you has enunciated tonight, I think is possible. It's cheap, it's fast, and I think we can make a lot of progress. And if you're not satisfied with the progress, you can order a hearing held anytime you feel like it. But I think given the level of good faith cooperation to date and voluntary measures on art.com's perspective, I think we have a very feasible opportunity to reach an agreement that's satisfactory to you. So a continuance would, I think, be very constructive. Thank you.
Can I ask the attorney if it is set for this for a modification or revocation hearing, and it does appear that progress has been made, what is the process? Is there a process for saying, for stopping in midstream?
In midstream, is the next meeting October 25th?
Yes.
You meet once a month? Well, then the normal protocol would be you wouldn't be able to interrupt it then, but until you got to the 25th. And then when it got to the 25th, you could consider whether or not to proceed at that point or whether to continue it there. But very likely there would have been a lot of time and energy and money spent by all parties, both art.com and by the city and possibly by the residents, to present their views and their evidence as to what ought to happen. So, but before then, you would have an order of the Planning Commission to proceed, and no one person could act to direct the parties to proceed differently until the Planning Commission spoke again. Did I answer the question, I hope?
I feel confused.
No, I'm sorry. Okay. Well, I understood the question. I saw some faces that maybe it wasn't understood. I understood the question to be if you ordered the revocation proceeding for October 25th, could, before that date, a decision be made not to proceed with the revocation proceeding?
No, we had it. It looks like it would be calendared for November 1st for a special meeting.
Oh, well, I'm sorry. Then I guess I misunderstood the facts. So, well, on October 25th,
it's a regular meeting.
At a regular meeting, you could take some action as what to do on November 1st, but you could not, before you met again, determine what to do on November 1st. Does that answer the question?
Well, so if we decide to go ahead with a action to modify the permit at this meeting today, and during the intervening month arrive at a solution that everybody's happy with, would we then abandon?
Well, they would come to you, the parties would come to you and say, we have a solution, we don't want to proceed with that revocation proceeding, and they could present that to you instead, because they would then have basically something they would be asking for approval of rather than the proceedings, and you could, if it were, you could then consider that at that meeting.
So we incur a lot of expense if we proceed with this action to modify the existing permit?
You likely would, unless the parties themselves came up to a resolution that they decided they were comfortable with and wouldn't have to. They wouldn't have to proceed with those expenses any further, but it wouldn't be finalized until it were presented to you.
So we could proceed with issuing this order at the soonest possible date, which it looks like would be November 1st, and also agendize the item at our regular October meeting, so that if something happened in the interim, we could also rescind.
That sounds like a feasible option, yes. But before October 25th, certainly there would be quite a bit of activity.
Madam Chairman, as a point of order again, our request is that you continue tonight's hearing. Tonight is for the purpose of deciding whether to pull the trigger on evidentiary hearings, in effect the formal prosecutorial defense aspect of a permit revocation proceeding. Our request is that you give us another month to do what we've done to date on a rush basis. Only we have plenty of time in which to attain an improved solution that addresses the technical factors and the policy factors that you've enunciated tonight for the first time. I think that's plenty of time for us to meet. As we have done tonight, we would come back to you with a proposal worked out with staff. I think you've seen from staff's perspective that we are close. There's not a vast gap between the substantive policy positions. Because if you order the hearing now, what we have to do, these are trials, administrative trials. We put on evidence, we cross-examine witnesses, it's a big hoo-ha, and it's very expensive and time-consuming. It's completely a procedural exercise, unrelated to working out the substance of a simple agreement. And if we could instead take this intervening interval and work on the substance of a new proposal that addresses your concerns voiced tonight, I think we can make satisfactory progress, bring it to you well in advance of October 26th. And at that point, you can decide, at that next hearing, you can decide whether the progress has been sufficient. But the bureaucratic overlay to date has been burdensome. To order a hearing just ratchets up the administrative hoo-ha of not solving the problem, but doing a process. I think we can solve the problem in the time we have before the next hearing, if you'll continue tonight's hearing and not order the next revocation evidentiary hearing. Thank you.
Staff does concur with that request that we would continue the hearing because it will be very expensive for the city to prepare for that hearing with the full evidentiary hearing and give a chance for a settlement to be reached before the October 25th meeting. And if one can't be met, then we proceed at a later date you adopt the order that night, we proceed at a later date with the administrative nuisance abatement action. But
in other words, you'd spend a lot of money before the next meeting date.
Yeah.
Correct.
And it would be November 1st if it was to be actually moved, the resolution to move forward.
If on October 25th, if you didn't meet your resolution, I don't think it would be November 1st, no. Because you'd have to adopt the resolution that night, and you'd have to give a minimum notice of, I believe, a couple of weeks before you could have that hearing. And you could set a special date hearing for those days out. Or you can do, as Mr. Siegel previously alluded to, do a dual track, set the hearing for November 1st now, adopt the order, and also put it on the agenda for October 25th for a status update to see if something's happened. But my concern, from staff's concern from that perspective, is you are going to go through a lot of resources preparing for that hearing on November 1st.
So right now, we've got a condition of approval that mandates that both signs have to operate the same. If we wanted to decouple those signs for this 1 month period, how do we procedurally go about that tonight?
Well, from staff's perspective, we would talk to art.com tomorrow and get going on the settlement discussions. And if we're able to come to some conclusion of something that we think is workable taking into the commissioners' members, I would implore them to start that before October 25th so we can provide examples of whether or not that works. Because we don't want to come back to you with a hypothetical on October
Right.
25th. I think
So
that's what
even
you're
though
asking.
it
It
would
won't be
be-
binding on any parties at that point until something's approved by the Planning Commission, but at least you'll have visual data to analyze in making your decision.
Even though it would be against the conditions, that would be fine. We would just skip that for now because they're supposed to be the same.
Correct. We would enter into some sort of agreement where we would give them some leeway to experiment with those, with decoupling, if that's what you're talking about.
Mm-hmm. Okay.
There's nothing prohibiting them from, I mean, the decoupling, yes, but from decreasing the luminosity and changing the colors to a deep red at night, there's nothing prohibiting from that in their permit.
Or shielding, or, yeah, any of the options. Okay.
Yeah. So the existing condition does say the two signs may be different colors at the same time. I don't see anything requiring them to be the same color or the same luminosity, if that's even the right terminology, luminosity, lumis, whatever the correct terminology of this is. But there's nothing requiring that for both signs at the same time.
Okay.
De facto, they're uncoupled now.
Any further questions?
Are there any further questions? No.
So how can we get some sort of an assurance that some action will be taken soon, like within the next week? Is there any way that we can mandate that?
Well, I think
I gathered that that question was addressed partly to me. I can commit that art.com will reopen a dialogue with city staff tomorrow and work diligently and rapidly toward whatever solution can be reached. I have 4 pages of notes from tonight, and we know a lot more now than we knew coming into this hearing.
I'm sorry, go ahead as well. Thank you.
Thank you.
I didn't know if the question was addressed to me or not.
It was kind of an open question to
Okay.
whoever
Well,
answered.
I think it's been answered, and what I would have said to you if it were addressed to me was, you just have to, it's your power of persuasion and conveyance to art.com of the seriousness of your concerns if you were looking for something that, from a commitment from them, as opposed to anything that you could do that would be legally binding upon them. But if you're serious about potentially opening up revocation proceedings now or at another point, you would convey that message.
Well, I'd like to make a motion that we postpone this for another month, then.
Do we have any seconds?
Which is what staff has recommended.
Staff doesn't live here.
Do we have substitute motions?
I would move that we proceed to initiate an action to modify the existing permit.
I didn't hear, was there a second for the first motion?
There was not a second.
Okay, I thought I heard one, but obviously I didn't.
And we have to do one or the other.
Yes.
Yeah. Well, I'm sensing we need maybe a little more discussion here because
Yeah,
I don't.
it's possible.
I don't think we. I'm okay. I'm gonna just think out loud here. I'm wondering if it's even possible, or if there's any interest for having for scheduling a special meeting in the nearer future than our next meeting, than our next regular meeting.
I think that's as soon as it's possible. I'm not totally sure, but we did go over schedules, and
Okay.
that was about as soon as it could happen.
What, the October 23rd?
The
So we have a special meeting of...
Maru, I'm not sure if you're up on schedules, but
Yeah, I mean, if we can work out the schedule, we can hold a special meeting. It's up to the commissioners.
we could
Yes.
sooner.
Yes, of course.
Would you all be
So we could have,
amenable to
absolutely.
a week, 2 weeks,
Mm-hmm.
a meeting in 2 weeks?
Yep.
Is that possible? Yeah?
Enough notice?
Yeah.
Enough notice?
Yes. Yes.
Okay. Well, that's an option.
I think
So,
that's a
I mean,
good one.
I mean, I think so. So what if I can finish the thought, what I'm thinking is we could we could try to schedule a special meeting, say 2 weeks out is kind of the timeline I was thinking.
Mm-hmm.
At that point, we could consider a settlement if there is one. Well, we could even issue the order tonight if we felt that was appropriate, and at the special meeting, we could accept a settlement if there was one. It's only 2 weeks out, so it's not as far out. It doesn't cost as much time. I mean, it's not as much time preparing for the hearing is what I'm thinking, if a settlement is able to be reached in that short amount of time.
Well, I think you offer a good compromise that I would be willing, if we had a special meeting 2 weeks out, to postpone this for that 2-week period. That gives people 2 weeks to
Get it
get things together and show us that this can be resolved.
Yeah, it's not ideal to me. I mean, it's not an ideal solution, but I just think we've had 2 motions and no seconds, and so I'm just, I'm trying to get us somewhere.
Would that be a motion then?
Sure. So I guess, can I make it all as one motion that we will issue this? Okay, let me read the recommendations.
Decision to initiate action.
So it's
to revoke or modify.
yeah. I'm just trying to find the language here. So.
Can I just ask one question? In the resolution, it says, as I see it, is it the last page of the packet? It mentions October 25th for the hearing on the revocation proceeding, but I've heard it mentioned it being November 1st. Is my packet out of date then?
No, that was in the staff report.
Okay. So I just want to make sure that if there's a resolution adopted, we need a good record as to which resolution is being adopted.
Right. We would be, to the extent there was going to be a hearing ordered, we were, subsequent to the agenda going out, we realized that November 1st would really work better.
Okay.
To hold just a separate item that evening as opposed to it being a part of their normal agenda when there's a bunch of other items as well.
Okay. And the commissioners then have that updated resolution. So if you were Commissioner Moss to make that motion to initiate the revocation proceedings, it would be for proceedings on November 1st?
Right.
Okay.
Yep.
Just want to make sure the record's clear.
Right. So
proceedings 2 weeks from this date, not November 1st.
No. So what my motion was, going to be was to, I was going to move this resolution to order the initiation of an action to modify the existing major sign permit, with the understanding that we would try to schedule a special meeting approximately 2 weeks from tonight, at which meeting we could accept a settlement if one was available to us, and if it's not available to us, we can cancel the meeting. I mean, we cancel the meeting for lack of a quorum. We cannot show up. Whatever.
Is that?
Yeah, I mean, that would be, or the motion could be to set the special meeting in order to consider that, and then you could decide at the special meeting both if there's a resolution and also as to whether to proceed with the revocation proceedings. Or you could just decide to set the special meeting now to consider all of it and determine when to set a revocation proceeding if that's the choice to go to now. So any of those options are available.
So schedule time.
That sounds good.
We do it on the same day.
Well,
So, for the record, that
2 weeks from
that
today.
would be approximately the 11th of
It's the
October.
11th of October. Is that,
It's okay with me.
can everyone make that meeting?
Yes, October 11th.
yes.
Yes.
Okay, so.
Okay. So I think then I will move, do we need to move to schedule a special meeting
Need to move to schedule a special meeting
for
on
October 11th, at which we will consider a settlement of this art.com matter if it's available to us, or we will also consider the order of the initiation of an action to modify the existing sign permit.
In 2 weeks. Is that
Just
possible?
what you're doing is possible. We
Great.
just want to add one more point that it's not going to save a whole lot of money by just continuing it for 2 weeks. We're going to have to, both parties are going to have to start gearing up right now for the administrative trial, and that's fine, but you need to be made aware of that. Both parties agree that if this is set for November 1st, with a special meeting a couple weeks from now, we wouldn't really have the resources or ability to prepare for that trial on November 1st, starting to.
But the motion I just made was not to issue this order right now. It was to do it
At the special
in
meeting.
2 weeks if there's no settlement. So
Then the hearing could be
At the special
later
meeting,
than
you would decide whether to issue the order if there was no settlement.
right, correct.
So in essence, this is continuing this until the special meeting.
It's continuing it for 2 weeks rather than a month. Yeah.
Which I think is a good compromise. I would second that motion.
Yes, all right, well, I guess,
Point of clarification, are you
initiating the order tonight, or are you going to put that over for 2 weeks and decide in 2 weeks to initiate the order if you don't
Correct.
have a settlement?
Correct.
Correct.
All right, thank you.
Giving art.com 2 weeks to get it worked out.
Yes.
Yes. So we have a motion and a second.
Yep. Should I say the roll call?
Yes, please.
Commissioner Donaldson?
Aye.
Commissioner Moss?
Aye.
Commissioner Sherman?
Aye.
Vice Chair Cardozo?
Aye.
Chair Kamurli?
Aye.
Motion is passed.
Forgot.
Oh, we forgot
Commissioner
Commissioner
Tam.
Tam.
Oh, I'm so sorry, Commissioner Tan.
Aye.
Okay, thank you all so much for coming and telling us all the things that have been happening with you. And art.com, please work it out with staff and make it happen. Feet to fire. 2 weeks. Thank you all.
One color, very dim, shielded.